Good afternoon, everyone, and welcome to the second of the three-part webinar series celebrating the International Open Access Week at the Indian Institute of Science. The topic of today's panel discussion is copyright a hindrance for open access in India? I am Venkat Nadella, a Policy Research Fellow at the DST Center for Policy Research at the Institute. I will be your host this afternoon. Each year for the past 4 years, we at the Center for Policy Research are taking part in the International Open Access Week celebrations by organizing talks, speeches, and keynotes from open access experts. Through these talks, we engage students and faculty from our campus, as well as engage citizens across Bangalore and across the nation. These activities are led and guided by Professor Subbaiah Arunachalam, a visiting professor at our center, and a leading science policy scholar renowned for his open access advocacy. This year, while social distancing measures have restricted our work from our homes, the Center's Open Access Week celebrations have gone global as well as virtual. Yesterday, we had a lecture from Professor Jean-Claude Boudon on access equality and cognitive justice. He delivered a wide-ranging lecture on problems with scientific journals and research evaluation, as well as offered an action plan on how the Indian science policy community can address some of these challenges. His recording, the lecture of his recording is the recording of his lecture, is on YouTube. Tomorrow, we are scheduled to have a discussion on equity and inclusion in global open access from the Latin American perspective by Dr. Dominique Babini and Dr. Ariana Becerril Garcia. They'll be discussing the need for more South-South dialogue and cooperation in the open access movement. After searching far and wide for panelists to follow Professor Boudon, we were pleasantly surprised, although not by very much, to find two of the very best right here, well in our own backyard. Ms. Anubha Sinha from the Center for Internet and Society, and Dr. Arul Scaria from the National Law University in New Delhi. Before I introduce the panelists, I would like to introduce our moderator for the panel discussion, Mr. Madhan Muthu. Mr. Madhan Muthu is the librarian at Azim Premji University and a visiting researcher at our center. He researches and writes on open access issues in India and is a member of the expert panel on open access, advising the government of India's upcoming science, technology, and innovation policy. After the panel discussion, we will be joined by Dr. Francis Jayakanth and Ms. Hamsa Kalyani, who will guide us through audience questions and engage in an open discussion with the panelists and the moderator. Back to our panelists, Ms. Anubha Sinha is a researcher and a senior program manager at the Center for Internet and Society, a think tank based in Bangalore and Delhi. She works on various digital rights issues, including copyright law and openness. Dr. Arul Scaria is an associate professor of law at the National Law University, Delhi, and co-director of the Center for Innovation, Intellectual Property, and Competition. His key areas of research interests and specialization are innovation, intellectual property rights, and competition law. He is one of India's leading open access activists and a member of the expert panel, along with Mr. Madhan and Dr. Francis, on open access, advising Government of India's upcoming science, technology, and innovation policy. To guide us through the next 40 to 45 minutes of the panel discussion, over to you, Madhan.
Thank you, Venkat, and thank you, Arul, and thank you, Anubha, for your presence here. To begin the panel discussion, before beginning it, I would like to give a background about the problem here. I think many of us in the audience may know about the problems with copyright and open access, but still, it's better to have a kind of premise for this discussion. To have a premise, I would like to give a brief background about the problem. It's essentially a problem statement. Well, scientists in general use journals to communicate their findings, essentially to peers, but one can say to all possible would-be users. And I would be able to say that journal is the main medium of communication in science. Scientists here, the scientists are the creators. Creators, I'm saying, I would like to relate their activity with the copyright. So the scientists are creator here. So I would like to call them as creators. And they are the owners of the content that they produce in that sense. Copyright as a law in general, in all over the world, including in India, offers creators, in this setting, the scientists, the right to produce, reproduce, distribute, perform, display, and so on and so forth for a stipulated period of time. The copyright law offers these much rights on their work. Traditionally, scientists write in journal for claiming priority of ideas and for academic reward. I would say that. Also, more interestingly, scientists volunteer for the peer review, which is an essential feature, an important feature of scholarly journals. They simply volunteer. While publishing a paper in a journal, scientists and scholars surrender their copyright or their ownership on the contents that they produce to a publisher. No money changes hands. So essentially, the scholarly articles are author giveaways. A typical journal's copyright agreement transfers from the owner, in this case the scientists, to the publishers the rights for paper publications, reprints, microform, electronic media, and the media that have not yet evolved. So they essentially take away all the rights. And publisher is, in the sense, owns the complete work, owns the complete rights to a particular article, and the profit of selling these articles, packaging, packed in a journal, or something. They own the profit also. The rights of the creator here, the rights of the scientist become secondary to the rights of the publisher, as the scientists transfer their copyright or their ownership to the publisher. Such assignment is very common in the production of scholarly journals and monographs, not just in India, but all over the world. Here, now, the science, by and large, the science journals are published by private publishers. Having said that, I would like to point out here that scholarly publishing is a perfect example for an oligopoly market. Only a few publishers dominate the market. Universities and learned societies also publish journals, but they are minority here in this. The system for producing and distributing scholarship, the scholarly journal production and distribution in general does not adhere to the free market laws. One may challenge the ideas of Adam Smith, the supply, demand, and an invisible hand and all is not seen here. Scholarly publishers sell journals and articles at a price of their choosing. All others have to buy, whatever the price they dictate. So it's not a classical, the classical market rules. In short, the copyright of the intellectual efforts of the non-profit academic research sector is transferred through the scientists to the private publishers. When the publishers resell the intellectual efforts back to the academic sector, the problem starts. See, the academy grumbles that the price is not worth, or they say it is unaffordable here. But they first surrender their right to the publisher, and then they grumble. So this is a problem here. And in India particularly, the higher education and research sector is largely funded by the government. Open access proponents say, in general, the scholarly information should be viewed as a government information in that sense, because government funds for this research, or the information for the public good. This is the way we tend to view the government-funded research. They argue that, like government information, it ought to be widely available as a matter of public policy rather than treated as a market commodity. So these are the problems here. First, the scientists and scholars as creators surrender their entire right to publishers, and the publishers dictate again about the rights of the creators back, and they sell the products at unaffordable prices. here the copyright as a tool is not really helping the spread of knowledge. Rather, it restricts. Clearly, it supports the private profit. With this background, we are going to discuss. I think we are going to ask questions to the panelists who are experts in this field to enlighten us about the copyright law in India, the meaning of rights and ownership in general, the moral and economic values in the trade of rights in scholarly communication setting, and the process involved, and all that we are going to discuss. But to start with, I would like to ask the panelists take a few minutes, for 6-7 minutes, to give an introductory remark on the question, the very question of the discussion, which is, is the copyright the hindrance for open access in India or in general elsewhere and all over the world? May I request Anubha and Arul to start their introductory remarks, and each one of you can take about 7-8 minutes to start with. May I request Anubha to start with? Thank you.
Thank you, Madhan, and a warm welcome to all the participants. I hope I'm audible, and if my voice turns faint, please let me know.
Sure.
So, I will be dealing with the question of how copyright law is both prescriptive and enabling for researchers. And I hope by the end of my session and my co-panelist session, we will be able to inform on aspects of the law that require a relook or a tweak in their utilization. So what is copyright? Think of it as a bundle of exclusive rights held by the copyright owner or holder. This means that only this owner or holder has the power to decide who reads their work, reuses their article, what format can the article be made available in. This is an awful lot of power, and these choices ultimately decide the fate of the article's reach, impact in the field, and value to society. Indirect, this also determines the return on the taxpayer's money, who is ultimately funding this research. So in this legal system, the author primarily has two types of rights. One is the moral and the other is the economic set of rights. Moral rights are irrevocable, and it means that no matter what, the right to be identified as the author of an article cannot be taken away from you, and neither can your work be distorted. Economic rights vest in the author when the author is also the copyright owner or holder. In most research projects, authors are majorly responsible for creation by authoring their articles. That makes them the principal owner of the copyright in the article. But there are exceptions to this example, and I can maybe reflect on that later in the Q&A. So when publishers insist on copyright transfers, there are primarily 6 types of controls that the author is kind of transferring to the publisher. This includes readers' rights, reuse, copyright, author's posting rights, automatic posting in other repositories, and the machine readability of the article. After the transfer, the publisher gets to decide whether readers should pay per view or should they read the article via a bulk subscription. What is the kind of reuse that the author and the reader can engage in? Whether the authors can post the article in any other public repository or even a private repository, and what version of it can be posted in other repositories. So, as I mentioned in the beginning, copyright law is also enabling for researchers, and to that extent, it is actually incumbent on researchers to use it effectively to not only meet objectives of academic freedom, but also in the interests of science and societal development. The enablement exists in a set of provisions in copyright law known as limitations and exceptions. Essentially, limitations and exceptions are rights that cannot be taken away even via a copyright transfer, and exercising them is not an infringement in the law. The underlying concept is that public interest uses in the sense of private use, education, research, study, criticism are not infringements. To illustrate, I will share what can be done, and instead of going into the legal concepts, mostly in the interest of time, for example, an author can circulate their article privately to a select group. The author can share copies of the article with the group for purposes of teaching, and this can be broadly interpreted to mean in the educational and research context. To quote another article's data or research, the author can do so provided the attribution is correct and it is not a complete copy, but more so in the nature of value addition, criticism, appreciation, use. Preprints can and should be posted in public repositories, and postprints, since they are different from the publisher's version, are also sort of subject to the same academic freedom. Any copyright transfers restricting you from doing so, the kind of activities I just discussed, are essentially infringing on your rights. So the key takeaway here is that without your consent, publishers cannot take copyright away. One of the useful tools to do that is to perhaps license your article to the publisher instead of a complete copyright transfer. This means that you get the power to decide the future of your article with respect to the 6-7 controls that I mentioned earlier. There are plenty of modern addendums available on the web. Essentially, these are licensing agreements. One of the notable ones is the Spark Author Addendum. It enables you to use the publisher's version of your article for non-commercial purposes. I think even sites like Sherpa Romeo are great places to understand more about copyright and various policies of publishers. This can be an educational tool for researchers to understand and see what publishers' copyrights arrangement work the best for them. So I think I will stop here and I will let Arul take over the next part of the discussion, and I'm happy to take any questions in the end. Thank you.
Thank you, Anubha. I think, may I take that your answer is no. I think if we can use cleverly, I think open access is possible within the broad copyright framework. I think we can discuss it later. Now, may I request Arul George Scaria to give his introductory remarks. Thank you.
Thanks, Madhan. First of all, thanks to DST Center for Policy Research for inviting me back to the Open Access celebrations. I was fortunate to be a part of the celebrations in 2018. I really enjoyed those discussions. And it's wonderful to be back to this particular community. And that too, to speak on something really fascinating, that is copyright a hindrance for open access in India. So thanks, Anubha, also for that excellent introduction, because that kind of sets background for two questions which I might want to ask. And there is a context for asking these two questions. So when Madhan had the discussion with Anubha and me, so we were discussing about different possible topics, and he said, okay, why can't we just move with one question, and that was, is copyright a hindrance for open access in India? And the immediate response that came to my mind was, no, it is not an hindrance to open access. And there are many factors that kind of prompted my mind to say that the most important being, if you look at many of the open movements across the world, particularly the very famous Creative Commons movement, you will see that they are built upon the existing copyright system. So my general presumption was copyright is not a hindrance to open access. But having said that, so since the question was coming from Madhan, who is a great friend and also a person with extensive knowledge here, I thought, okay, maybe I should think a bit more about it. And I must say that I have changed my answer from no to maybe it is a hindrance. And I say it for two reasons, and that's by asking two questions. So one, is it really easy to relinquish your copyright related rights in India? So that's one question which I would like to pick up in this introductory session. And the second thing is, do works really enter public domain in India? So we'll discuss in like 2 minutes what is the concept of public domain for those of you who are not familiar with the technical term. But let's first look at the first question, that is whether it is easy to relinquish your copyright related rights. So like most of you, I must say that I was also under the impression that it's quite easy to relinquish all your rights or some of your rights. For example, when I share my slides with a Creative Commons attribution only license, I was under the impression that I am doing a perfectly valid thing under Indian copyright law. So I have relinquished all other rights except the right of attribution. But at least in the last couple of days, I was again looking back at our statute and then asking this question to myself, and maybe the answer is not that clear cut. So if you look at section 21, which is talking about the right of authors to relinquish copyright, you will see that there are two parts in which you can relinquish your copyright. So part one is to submit an application to the registrar of copyright in a prescribed form. So currently form 1 is being used for that. So if you look at the copyright rules, you can also get the template for that particular one. So it's not that problematic. The second one is saying you can also do it by giving a public notice. So everyone, including me, thought that, okay, when we are sharing our work with a Creative Commons license symbol, I'm kind of giving a public notice to the world saying, okay, I'm relinquishing all these rights. So I should be on a safer pedestal, right, when it comes to that relinquishment. But when we look at the Copyright Rules 2013, which is implementing the provisions of the Copyright Act, things are not that clear cut. So there is one chapter which is specifically dealing with relinquishment of copyright, and that's chapter 3. And if you look at chapter 3, you will notice that if you want to take the second part, that is by giving a public notice, you have to specifically include certain things in that particular notice, which are the specifically mentioned things are the class of the work, the title of the work, full name, address, nationality of the author, language of the work, name and address and nationality of the publisher if published, with the year of publication and even country of first publication. Then if the copyright is registered under section 45, you have to even mention the registration number. Then you should specifically mention the right or rights to be relinquished. And then you should also mention the date of relinquishment of rights. And if any one of you has used the Creative Commons, any of those licenses while distributing your slides or any of the materials, I'm sure that you must have noticed that you didn't include any of them, right? You just told the world, okay, what are the rights you are relinquished. So then here is an issue, because if the statute is very specifically saying that you can relinquish your rights only in two parts, that is either by submitting that very detailed form to the registrar of copyright or by giving a public notice, and then yes, you have to mandatorily include these and these things, then at least in my view, it's not a very, very easy thing to do. So even if you're an intrinsically motivated person who wants to give away all the rights in your work to the world, you still have to take lots of efforts to completely comply with what is being mentioned under the copyright rules. And to a great extent, this is also putting into question the validity of CC license as well as most of the other open licenses in the Indian context. I know that people like Sridhar, who are part of the CC movement, are attending this particular session. So I do not know whether this question ever came across, but at least to me, this is one question that needs to be asked. And to me, there is no policy justification for making this process so cumbersome. Because if you look at the way copyright is acquired, I think Anubha also briefly mentioned that copyright protection is accruing in an automatic manner, right? So you don't have to comply with any formalities to get copyright protection. But then what justification do you have for putting these much of formalities for giving away either the complete set of rights or at least some of the rights? So to me, this is one area where India needs to take radical reforms. Now let's look at the second question, whether works are really entering the public domain. So when a copyright lawyer or an IP lawyer uses the term public domain, they generally mean that that particular material is free from copyright or related IP rights or restrictions. In other words, everyone should be free to use it, share it in any manner they would like to. Is that really possible under the Indian copyright law? Again, I must express some doubts. And I am expressing that doubt because of one of the rights which Anubha was mentioning earlier during her presentation, that is a moral right. So as Anubha was clarifying, if you look at the copyright system in most parts of the world, but of course not in all parts of the world, you will notice that there are two kinds of rights. One is economic rights and the other is a set of non-economic rights, which some countries will call as moral rights, but which we call as other special rights. And there are two important rights which are recognized in this regard in the Indian context. So the first one is the right to claim authorship of the work, that is, your right to be identified as the author of the work. The second is the right to restrain or claim damages in respect of any distortion, mutilation, or modification or other act which has been done in relation to that particular work, if such distortion, mutilation, modification, or other act would be prejudicial to the honor or reputation of the concerned copyright owner. If you look at the statutory provision which is put on the screen, you will see that there is one footnote existing, two, and then there are some stars, which indicates that, okay, there were some changes that happened in the statute. So if you look at this provision historically, you will notice that this particular moral rights provision was linked to the term of copyright, or in other words, the moral rights were also ending exactly at the same time when the economic rights were ending. So in other words, if it is a literary work, the moral rights would also have got exhausted at the end of author's lifetime plus 60 years. But in the year 2012, our legislators made an amendment, of course, with all the good intentions, because we wanted to protect the works of all our great authors. What we did was we removed certain words from that second provision, that is, you can see from the footnote, which is done before the expiration of the term of copyright. And the implication of that particular change is that today moral rights are perpetual in India. Here I must add that not many countries in the world have taken this position, because everyone is aware of the consequences of giving a perpetual protection on any area of copyright law. So the only country or only major jurisdiction which I know which has taken a similar position is France. And if you look at countries like the United States, you will even notice that they don't care about moral rights at all. And that's also the reason why you don't even see much discussions on the impact of moral rights on public domain. So to a great extent, our discussions on public domain and our discussions on open access are controlled by narratives from the West. And if they are not facing a problem in this regard, we don't even discuss. And maybe that is the reason why so far no one even bothered about this particular provision. But at least since we are celebrating open access from the global south, maybe these are also some of the provisions which we need to look into. And these are just some of my remarks, and I look forward to the discussion. Thank you.
Thank you, Arul. Thank you. Now, Arul has pointed out a problem in the structure of copyright in India. And what I feel, what we feel in general is that I naively thought about it is just an imbalance in the negotiation between authors and publishers. Now, how this structure, the problem of giving up rights. For example, my question is, if I mention, I open a document and I mention for access and then data mining, one can use this document and all. Again, we should go and file properly relinquishing my rights and everything, and all should be done properly or not, I don't really know about it. But in general, Professor Balaram, the former director of Indian Institute of Science, mentioned in an interview by K.S. Jayaraman in Cider.net, if I'm right, I'm quoting his sentence. I argue that we should be permitted to put in the repository the article as it appears in a journal. For this, countries such as India should have a law specifying that the copyright for articles published with public funded research always vests with the authors and their institutions. So what is actually the question is for both. Anubha was mentioning about the author's rights, and then by author addendums, we will be able to claim rights of the authors and then make the content open. And you pointed out some structural problems. But Balaram, as an author, he's a prolific author, very highly cited author, and very accomplished scientist. He says he needs a law support. What does it mean? I think in what way we can protect the scientists' request like this? The question is for both of you. Yeah. We can stop. Yeah.
Anubha, you would like to go first?
Sure. Just a few quick thoughts. So, in my opinion, passing a law is not always the best solution to bring about social change. At basis this statement, for me, it's a little difficult to imagine the kind of impact first order, second order, something like this can have on so many stakeholders who are connected to this ecosystem. So I would definitely not assume that a law is the best route upfront. Secondly, keeping in mind our own social reality, I also don't know if a law is the quickest way to get to where we want to be. And it can be overly prescriptive, or it can be very open to interpretation. I think both scenarios might not sit well with the kind of varying disciplinary requirements that I've come across, in this ecosystem. So again, I would not be, I wouldn't claim that a law is the best route. It can definitely be considered as an option for reform. Yeah, thanks.
So maybe because of our training and exposure to law-related issues, I also tend to agree with what Anubha is saying, because I also think making a law may not really be the solution for the crisis which you are mentioning. Having said that, I also understand and appreciate the fact that there is a crisis and we need to address that. And to me, there are two ways in which we could possibly address it. So the first one is the funding agencies as well as the institutions have a very, very important role to play in influencing how researchers share their research outputs, particularly the public funded research institutions as well as the public funded universities. So one of the things which a funding agency, or for that matter a university, could do is to have a mandate which very specifically demands that a preprint or a postprint version of the manuscript as well as the data sets should be deposited in an institutional repository. So that's, I think, one of the solutions which we can definitely have. The second is a solution which Anubha was mentioning earlier, that is using an author's addendum or whatever it might be. Of course, in the Indian context, I haven't seen a good document which the Indian researchers can use for bargaining with the researchers. So there is a lot more work that needs to be done in this particular regard. But if we can have a proper document, and if we can also enable an ecosystem wherein you can have a fair bargaining with the publishers, I am hopeful that we will be able to address many of those challenges. So these are my quick thoughts on the question which you asked.
Following that, Anubha was also mentioning in her commentary on Planist that this institutional role in retaining copyrights was missing commonly in the policies, OA policies. Anubha, would you like to comment about that point? Okay.
Sure. I think given the contribution and the effort that researchers and authors put in most situations, in most research projects, the copyright would vest with the authors, but then there could be research projects where there is a greater degree of control that is exercised by the institutions or its officials. In that case, we can end up in a situation where there is either joint ownership of copyright, or we can also interpret the situation as the work being commissioned by the institution. In that case, the copyright may vest with the institution. So again, this is open to interpretation, but it would be definitely helpful if institutions can identify the kind of projects that they undertake, if they can conduct a study of, where they can exercise that degree of control, and exercise that degree of control basically to benefit the public, and obviously sort of negotiate with the publishers. And given that they might have better bargaining power, a practice like this can also go a long way in sort of changing the culture to be more balanced in terms of authors' interests and the public institutions and the public's interest.
Okay.
So maybe just to add to what Anubha was saying, so in one of our recent studies, which is like yet to be completed, we had tried to do a survey among the institutions in India as to who is owning the intellectual property arising from those institutions. So when I look at that particular data set, of course, I mean, again, I re-emphasize, it's still a work in progress. What I could notice is that even among IITs, the practices differ considerably. For example, in some cases, the institute is very clearly claiming ownership over the research outputs produced by the concerned researcher, whereas in some cases, the research outputs, whether it be a student thesis or whatever it might be, the copyright ownership is vested with the authors. So we can see substantial differences among institutions in India, and you can see the variance among, say, for example, IITs, among the central universities, and even among the state universities. So that's something which I just wanted to add. Madan, you are muted.
So the role of institutions in helping faculty members or scientists retaining their rights, in general, the institutional role. There was a kind of discussion or bill, the Protection and Utilization of Public Funded Intellectual Property Bill, that is for innovations or something. Is it, this similar kind of provisions were made that, when it comes to patenting, the scientists have to inform within 30 days to the institutions, then the institutions won't write and kind of things. Can you give a view about that bill and its status now? Is it somewhat related that we can also do something related to this copyright of publications or something? The 2008, 2011 between? Yeah. The Protection and Utilization of Public Funded Intellectual Property Bill are related. Arul,
I think Anubha, please go ahead, please.
Yeah, please go ahead.
Sure. So I think the idea was to ensure that the economic interest that is accrued out of innovation emerging from public institutions goes to public universities and research institutions. But something like this being translated to this particular context, I think then, the entire approach to something like this might change. And this is a cultural shift that has also been observed in many places where such laws have eventually been enacted, including the US. It becomes a race to get the maximum patents. It becomes for the sake of getting patents. You stop thinking about the value that is coming forth through the innovation that you created, whether it's going to translate to actual value for society, whether it can actually be commercialized, simply because you are able to qualify the formality of it being a patentable invention. I think that becomes the end goal. And I would think that if there is something that's if this becomes an inspiration for something like this in the current system, we should definitely not set up incentives in a manner where then seeking copyright or protection over an article becomes the end goal. The idea is not to, only give authors the copyright, but the idea is also to make the authors wield copyright in a way that benefits the public for real.
Okay.
So I kind of completely agree with what Anubha was saying. So if you look at the historical context of the so-called Bayh-Dole Act in the United States, and I think we were trying to take inspiration from the Bayh-Dole Act, you will see that the key argument behind Bayh-Dole Act was they were saying if you are not granting intellectual property rights to the concerned researchers, then they won't have an incentive to commercialize that particular innovation. And it is extremely essential for industry academia linkage to have something like this. And if you look at the current Indian context, you can see that yes, there is an intense lobbying that is happening for bringing a legislation of, I would say, similar sorts in India also. Of course, there was a previous attempt which thankfully failed, but now there is again an attempt which is happening. But even in the absence of that bill, if you look at the current incentive structure, you will notice that the incentive is more for going and taking patents. So let's look at the NIRF ranking parameters. So one of the important things or the questions which they ask is how many patents does your institution have? This is actually turning the incentives upside down, right? So today the incentive for a researcher who is working in a public funded institution will be to gather as many patents as possible rather than to share the knowledge with as many people as possible and let the society benefit. But this is an extremely undesirable result, and as Anubha was rightly pointing out, if you look at other countries, we can see that this is just leading to a race to patent rather than the race to knowledge generation or knowledge sharing. So I think this is something which we should be extremely worried about.
Thank you. Again, my question is about see, in general, scientists don't like interference from government. I was surprised to read Balaram's statement that government of India should help a scientist to own copyright for the published version of an article, because he always he has written openly that the government mandates in general on anything related to science production is not, he is not supporting it. Many scientists would agree that they don't like to be dictated at all. So what should be the role of the government as a funder here when scientists and scholars do not like interference in selection of journals, and they want academic freedom in that sense? And scientists enjoy their right. They choose their the journals they want to publish, all that and all. So what kind of accountability here? Because they are using public funds to produce that research, and that research finding is going to someone as a private entity. So what is the right to access knowledge for the funders here? I mean, they have to speak for the public. What is the right of the public here as a public, that what can I ask the scientist to, can I make the scientist to open that research to in the public domain? or what the government should expect from the scientists and institution in the accountability point of view? I would like to get your comments on this.
Should I go first?
Please, Anubha. Go ahead.
So I think, Madhan, your question essentially, the statement there, the problem statement is conflict between academic freedom and reasonable use of public funds.
Yes.
And then there needs to be a balance between that. So there is no such thing such as absolute academic freedom. I mean, I think, but then what are the kind of restraints that must be exercised there? And I think we need to look at the quality of the restraint there. I think that is where Arul's suggestion to change things at the institutional level is a very good suggestion. That gives the institution a great deal of flexibility to determine its own approach, to determine the kind of journals they might want to publish in, and also evaluate on whether the choice of the set of journals then is, a reasonable expense of the taxpayers' money. It is not entirely being left to the author. I think the government in this case needs to sort of take an approach where they emphasize on the responsibility of institutions and authors, but at the same time, it's somewhat of a light touch regulation, to speak in regulatory terms. And it's not very, very sort of prescriptive or interfering. And I really think it is high time that institutions start thinking about this problem at their own level and develop their own solutions. I think even that step can go a long way, and policies are always open to evaluation incrementally. We can always determine what the next step needs to be, but let's not start with heavy wielding. But of course, where there are issues such as predatory journal publishing, those sort of practices coming out, I think as an advisory, it's probably a good thing to spread awareness. But again, I'm not sure about creating an exhaustive list and imposing it. I don't think that's helpful.
Yeah, like Anubha, I guess I also generally feel that we should be very, very careful about granting government unlimited power, because power corrupts and absolute power corrupts absolutely. And if you are telling, okay, the government can decide where the researchers should publish, I'm sure that there would be enormous consequences on the kind of research we produce and the places we share our research. And the intermediary solution is definitely the kind of mandate which we discussed earlier, having a green open access mandate. So in that model, you are only saying that, okay, you need to deposit a preprint or a postprint within a specific time period, and preferably immediately, in an open access repository. And then you can go and publish in any journal which you want. So in that type of a regulatory system, which is, as I think Anubha was calling a regulatory system, we are able to achieve our goals of sharing, but at the same time, we are also able to retain the academic freedom. And ideally, we should try to look for those kinds of solutions rather than solutions that completely take away the freedom of researchers.
Thank you. The question now is to Arul. We are speaking about a lot of nuances in copyright and the rights of the creator and everything. And you have done an extensive survey about, and the policies also, government open access policies also saying, requesting authors in one sense to deposit their final refereed drafts, particularly DBT DST policy, and to the policy is asking the scientists to deposit their papers in repositories there. My question is, through your survey, I would like to know what is the level of awareness about the actual rights of the authors, because the moment they surrender the right, whenever I go and ask them, you can deposit your postprint in repositories, they say that I have surrendered my copyright, then it is a violation of copyright, and then infringing comes. Some of them I meet. In general, what is the result of your survey, the awareness level the gap between policy and implementation. Could you please give us some thoughts of about that?
Sure. So there are two things. So one, as you rightly pointed out, we already have some mandate, and the most important one is a DST-DBT open access mandate. So as part of the open science project, which we had initiated at the Center for Innovation, IP and Competition, we were really curious to see to what extent the researchers are aware and to what extent they follow these policies. So what we did was not a survey in this particular regard. Of course, we had another survey, but that was not dealing with this particular question. What we did was we filed RTI requests initially to DST for a list of researchers and institutions they fund, but then they sent us a specific list for a particular project, but which also had a long list of researchers and institutions. So what we thought, okay, we will reach out to those people and ask certain questions which can at least give us some idea of the extent of awareness of the open access policy, because the project was funded by DST. Interestingly, our results indicate that there was no specific communication that was happening from the side of DST on the existence of this particular policy. So the net result was most of the researchers were kind of vaguely aware of the fact that, okay, there is some policy like this existing somewhere, but since it was not conveyed directly to them, they didn't bother at all, which in effect also meant that there was hardly any complaints with the requirements of DST-DBT open access policy. And you can also see this from the way the DST-DBT related repositories are populated today. So if everyone was complying with DST-DBT open access policy, I'm sure that these repositories would have been full by now, but that's not really the case. So in this context, I must also add that DST-DBT open access policy is a wonderful thing, but there is hardly any compliance mechanism. So what if a researcher doesn't comply with the DST-DBT open access policy? To the best of my knowledge, and we also asked people at DST, has there been any instance wherein you have punished a researcher for not complying with the DST-DBT open access policy? The answer was no. And if any of the persons who are listening to this particular conversation can point out one instance wherein DST or DBT punished a researcher for non-compliance, I'd be very, very happy to go through the details. So yes, in a nutshell, yes, there are very, very serious issues with regard to awareness as well as implementation. From the survey, so certainly some of you might be aware of, we had also conducted a survey in 2017, the Open Science Survey, and we reached out to researchers working in different disciplines. I'll also share the link in the chat box in a minute. So as part of that survey, we tried to ask them what are the things they consider as important when they decide where to publish. Not surprisingly, open access or copyright was never a concern for most of the people, which again indicates that we don't really worry about trading away our inherent rights. We are only bothered about, say, for example, the impact factor or the prestige of the journal, which indicates that, okay, there is a serious problem in the current ecosystem, and we as a group need to collectively think about how to address this particular issue.
Thank you, Arul. See, the authors who have as creators who have the right, they are not exercising it to make it, to make their research accessible widely. Institutions do not care about the intellectual properties that are generated within a campus and how to maintain it, and how to make them available for posterity, free from financial firewalls and the contemporary researchers and all possible would-be users. Government of India is not interested in interfering in this matter. With all this failure, is legitimate way possible? Can commercial publishing and open access can these two items coexist? If it has to coexist, what we should immediately do? Who should act first? Or if all these fails, the civil disobedient movement such as the Sci-Hub is the only way for open access, for expansive access? What is your general comment? about this particular question. Anubha, again, you may start.
So, I mean, this is given that we're discussing from a very granular perspective, it's somewhat like being stuck in the weeds and being asked to do some crystal ball gazing. Sorry, but I'll give it my best shot. So, I mean, I'm guessing some of the folks here have read about the proposed approach on the one nation, one subscription thing that could possibly happen under the upcoming science, technology, and innovation policy. So that's partially fixing the demand side of the problem, but it would be very important for us to also, within India as researchers, to probably take a unified stance around green open access, as Arul rightly pointed out. I think that's definitely fixing the supply side of the problem. And I think both things are very sort of strongly connected. In the sense, if people complain about, I work at a think tank, and if I'm like complaining about how expensive it is to access, journal subscriptions from JSTOR or a Westlaw, at the same time, I'm publishing in a closed access journal. It's cyclical, and it needs to be fixed at my individual level as well. So I think the first step definitely would be institutional effort and green open access.
Thank you. Arul, your comment?
Yes. So, of course, I mean, it's a very, very difficult question. But to me, I mean, it's still possible to achieve our broader goals of open access through, I would say, perfectly legal path. And to me, the most important step which has to be taken is creating awareness at the level of researchers. So one of the things which I have noticed over the last couple of years is that the awareness regarding the need for open access, the need for openness in science as such, is really, really missing among researchers, particularly researchers in our country. And that's not surprising, because if you look at the kind of events which we have, generally most of those events are either sponsored by industry or maybe sponsored by certain specific funding agencies, particularly those from the West, which have certain vested interest in evolving a particular type of IP regime in India. And most of them are pro-IPs or pro-individual, I would say, programs. So we need to go back and address this primary issue, and that's by raising awareness on why we need open access and why we need open science in India. And once we raise the awareness at the level of researchers, yes, we will be able to make changes at the institutional level. And if all the institutions in this country start making changes, I don't think we need any further changes. So I'm having a very hopeful position here. I still think it's possible, but yes, we all have to work together in this particular regard.
Thank you. I have one last question, which is not about, because Anubha was mentioning about one nation, one subscription and all. See, libraries can provide access to public because libraries are again funded by public institutions, and they are public funded institutions in general. They are essentially, they have to provide access to information, but which is not happening because libraries tend to be more conservative and conservative sometimes, and they are very much law abiding. So if you look at the legal battles, I think you may not notice the battle between libraries and publishers, rather the battle is between merchants and publishers here. We are already over conservative. This is my personal opinion. But when I look at which is prepared by the NDLI, National Digital Library of India, has come up with a copyright which says the librarians have to get a declaration from users that they should obey the copyright law or something. But I look at library as a democratic an institution to democratize knowledge sharing. And I don't see any meaning in a librarian taking declaration from users and all. What is your opinion, Arul? I think Arul or Anubha, I think if you have looked, those who have consulted the document.
Anubha, you can go first, and then I guess I'll share.
Yeah.
Okay, quickly, I think instead of shifting the problem to the user, making the user take responsibility, I think it would be better if we took a deeper look inwards at our law. If you look at the Act does not have a single definition of library. It uses public library in certain places, it uses a non-commercial library in other places. There is a lot of, ambiguity there. Something as basic as e-lending right for libraries in this digital age has not been sort of sanctified in our law, which you find in a lot of other legislations. And it's if you look at the state of limitations and exceptions, libraries, museums, archives, these are very, very important public institutions for any country, and they do not get a good enough treatment. Speaking at the level of what libraries can do, based on my limited interaction and also reading, I think they tackle a lot of problems that includes legal, financial, technical. I think for them to be proactive about fixing copyright, I'm not sure how far in the sense the battle can go. It could go very far or not. But then it is also incumbent on all the kind of benefactors who benefit from such public institutions to put their weight behind such institutions and support copyright reform. I think that could be one way of looking at it. It's high level, but this is just my idea.
So thanks, Madhan, for raising this extremely important question. So because libraries have a very, very important role to play in communication of knowledge. And as you rightly pointed out, yes, there was a document which was released by NDLI recently, and I got a chance to look at it yesterday. And I mean, I was like completely surprised by the way in which it was drafted. So there are two things which I definitely would like to flag, and if you may permit, I would also like to share it on the screen because I think more people should see this. Just a second. So yeah. So I think here is what Madhan was mentioning, this declaration by users or patrons of library. So essentially what they are saying is, yes, if there is a user coming to a library, yes, you should actually use a kind of form, and there is a declaration saying that I am not doing any nonsense. That's what I think essentially this form is saying. But then I was asking myself, I have gone through copyright law multiple times, but where in the copyright law is this being said? So, and where are you actually bringing these requirements from? Because if a particular user is violating the provisions of the copyright statute, then it is a responsibility of that particular user to face the law. For example, I as a user might have different kinds of exceptions applicable to me under section 52. And if a copyright owner is upset by the fact that I have made maybe 10 copies of a particular book, then yes, they should actually sue me, and then it is my duty to tell the copyright owner that, okay, even though I have made these many copies of these many pages, I am exempted from liability under these provisions. And asking libraries to collect these kinds of information is threatening both librarians as well as the users of libraries. And these kinds of attempts should be restricted or pushed back at all levels. So this is one thing which I wanted to tell. The other interesting statement which I saw was in the context of educational exception. So if you look at the last statement in that particular section, it says the extract should be relevant to the subject of the course pack and in no case should involve the whole book, however short the copy. Again, absolute nonsense means absolute nonsense, because we had a dispute in the context of photocopying that was happening in Delhi University, the famous Rameshwari photocopy shop case. And we had two judgments coming from that particular decision. There is a judgment of the single bench as well as there is a judgment of the division bench. In both of these cases, it has been very, very clearly clarified that the scope of section 52(1)(I), which is dealing with educational use exceptions, is very different from the scope of fair dealing exception, which is dealt with under 52(1)(A). Under section 52(1)(A) fair dealing, some people might make an argument that, okay, there should be quantitative restrictions because there is also an analysis of whether something is fair or not. So quantitatively as well as qualitatively, we need to look at it. But when it comes to the educational use exception, the judges have clarified without any ambiguity that there are no quantitative restrictions applicable. And in the division bench judgment, which is the latest judgment available in this particular regard, it has been very, very clearly mentioned that as long as the faculty member can justify that this is within or this is important for furthering the objective of the course, as long as I can defend that it is important that I read this particular reading material as part of my course, no questions can be asked on how many pages have been copied or whether a complete article has been copied or whether a complete book has been copied. So this is a very, very clear-cut position that is existing in law. But when you look at a document like this, they are saying the exact opposite and they are trying to threaten the users. And this is the kind of things which we need to resist as a society, as a group. And these are important issues that need to be discussed. And thank you so much for asking this question.
Thank you very much.
Just to quickly note there, and as Arul said, it's very scary that the liability is being passed on to the users and librarians. There are many countries in the world which actually provide protection to librarians and users from, any sort of infringement charges. So there is sort of that legal protection provided to them, and it is indeed scary that, as Arul pointed out, we seem to be moving in the opposite direction.
And also, if you look at countries like the US, you will see, or Canada for that matter, you will see that librarians, I think, play the most important role in advocating for users' rights.
Yes.
But unfortunately, in the Indian context, I fail to see that kind of a spirit coming from the side of libraries. Of course, there are exceptions like Madhan, Francis, and so on. But most of the librarians are silent on these issues, and that's really unfortunate. And here I must also add one more small thing, which I think the librarians in this group should definitely consider. Most of the seminars or conferences which are conducted by librarians are sponsored by publishers. And maybe this is also causing an extremely harmful effect on how we as a community share goods. So maybe we need to find alternate sources of funding so that, more balanced discussions can be happening on librarians forums.
Thank you very much, Anubha and Arul. I think as a librarian, I have taken a lot of messages from your answers, and library community has to play an important role here in all your suggestions. I think they have to work for the institutional level mandate, and they have to convince their faculty about their rights. Creating an awareness at the faculty level, and then they have to work on the licensing forms that they sign with publishers, where we should include the public use because they are public institutions. We should ensure, because as you rightly pointed out, I think we are here to maximize the usage of the knowledge, that we are not here to restrict access here, that we can't do morally. So we have to work, particularly the library community, if it works in full spirit. I think the legitimate open access is also possible. We don't want to create fugitives, or we don't want to make Aaron Swartz kind of people commit suicide. These are all serious. We should take a serious note. Library community, not just scientists, because they show some kind of indifference for a long time. But for library community, there is a lot of stake here. That as a librarian, I would like to take all your messages. With that, I would like to pass the forum to Francis and Hamsa, and they will now the session begins with them. They will moderate the session. Thank you very much for your kind time. Thank you.
Yeah. Thanks, Madan. Let
Thanks,
me
Madan.
quickly introduce and hand it over to Dr. Francis and Ms. Hamsa. Thank you, Dr. Arul and Ms. Anubha and Mr. Madan for a stimulating discussion on the structural and legal aspects of corporate law and its interaction with the practice reality in the social context of open access in India. I also thank you for the very illuminating discussion towards the end on framing libraries as democratic institutions, part of the social infrastructure of the knowledge economy or knowledge society in India. This sets the perfect stage for me to introduce Dr. Francis and Ms. Hamsa, both of whom are library professionals, lifelong library professionals, to guide us through the Q&A. A couple of very quick housekeeping rules. First, we will have a group photograph towards the very end of the discussion once all the Q&A are done. So please hang around. Second, Dr. Francis and Ms. Hamsa will take the Q&A. If you have a question, please raise your hand. One of the moderators will call your name, and when it's your turn to speak, please remember to turn on your mic, and if you wish, your video as well. Okay, so Dr. Francis Jayakanth is a scientific officer at the JRD Tata Memorial Library at the Indian Institute of Science. As a scholar and library professional, Dr. Francis is among the most active open access practitioners and advocates in the country. Among other things, his work in setting up India's first institutional repository, ePrints at IISc, and for coordinating and moderating the LIS forum, a discussion forum for library and information professionals in India. Along with Mr. Madhan and Dr. Arul Scaria, Dr. Francis is a member of the expert panel on access to knowledge and resources, advising the Government of India's upcoming science, technology, and innovation policy. Ms. Hamsa Kalyani is Library and Information Officer at the National Institute of Advanced Studies, NIAS, since its inception 3 decades ago. At NIAS, she is responsible for designing and developing the library's collection and services, as well as maintaining the institutional website and repository services. To take us through the Q&A, over to you, Dr. Francis and Ms. Hamsa. Thank you.
Yeah. Thank you very much, Mr. Venkat, and thank you for the kind introduction as well. Am I audible?
Yes,
could you please acknowledge if I'm audible?
Yes, you are.
Okay.
Yes.
Thank you. Yeah. I would like to first thank Madan, Professor Arul, and Anubha for an excellent introductory comments and also clarifying on various issues raised by Madan. Madan, in fact, raised very pertinent and meaningful questions, and then these were answered very insightful manner by both Anubha and Dr. Scaria. Thank you so much. Now between myself and Hamsa, we will be alternating. So we will coordinate this question and answer sessions. So if I take the first question, the next one will be handled by Hamsa. So that's the way we plan to go about. So before I invite any of the audience to pose the question, I have a question myself. And after that, I would take a question from the audience. Now, Anubha, you mentioned that there is a provision to use author addendum to seek permission to retain certain rights for the authors themselves. Now, you know, administratively, it's very laborious process. This has to be done at an individual article level. And a typical author may publish about 3 or 4 articles every year. And then seeking author retention rights through author addendum, I feel it's not practical. Now, is there a better way of handling this? Now, Planus, as we all know, gives the European authors to retain their rights. Now, should India join the Planus movement, or can we have something similar to the Planus? Also, can we have something like one nation, one open access policy? Now, what is happening with respect to open access policy is that it is being done on a piecemeal basis. Now, every institution is expected to have an open access policy, and even if there is one, there is no compliance at all. For example, Professor Arul pointed out about DBT DST open access policy. There's absolutely no compliance at all. So in this context, can we have one nation, one open access policy for the entire country, at least for the centrally funded technical institutes?
Thank you. Many questions there. Firstly,
yeah,
yes.
Anubha or Mr.
Okay, so yeah, so many questions there. So firstly, yes, negotiating individually the publisher, authors have limited bargaining power in the equation. It could get cumbersome. And I think this is where the role of the institution becomes even more important. And I think something like this, should definitely be done with some support from the institution. Maybe that could make the process and the formalities easier for the author to navigate. Secondly, on joining the Plan S, I think one of the central reasons we walked away from the Plan S, to the best of my knowledge, was the cost. Because the route there was gold open access. And so I'm not sure if on the specific point that is a feasible option. On uniformly going for one nation, one open access plan, like I think Arul pointed out, and I think I also reflected on that, the fact that there is not too much unison around adopting green open access as yet. So I'm not sure what the prospects of imposing or bringing all researchers into agreement, into the fold in adopting a uniform open access policy across institutions, across disciplines. I'm not sure of the feasibility of that. Of course, that would be ideal, considering that if we had to take into account the fact that we're a developing country, we have limited sort of, public expenditure sort of that's capped and so on and so forth. But again, I think it really depends on the specific circumstances.
Thank you.
So, I mean, on the very important question which was posed by Francis. So, I also completely understand, yes, it's going to be a laborious process, but it's also not an undoable thing, right? So, if you look at, say, for example, how the government is currently funding IPR cells in all the universities, can we think of a similar thing for communication also? I mean, if the government can fund IPR cells, why can't it also fund an office in every university for communicating the results which are generated from that particular university? So it's not an undoable thing. The only thing is that we need to convince our researchers as well as the government that this is something of priority. At the moment, I think the focus is more on protecting our things rather than on sharing our things. I think that's the first thing. I think the second issue is, yes, should we have a national level open access policy? See, I am a person who believes in diversity, and generally I think a national one-size-fits-all approach in the area of open access can be a big failure. So ideally, we should leave it to funding agencies as well as institutions. And the beauty of that thing is that they can fine-tune the open access system according to the specific requirements of the institution or the specific requirements of the discipline. For example, in a particular discipline, it may not be desirable to release a data set at the same time of generation, but in another discipline, it might be the best way to go. So, in a nutshell, I generally feel that we should promote diversity in this area, but yes, we as a nation should definitely try to adopt green open access.
Yeah, thank you, Dr. Scaria. Hamsa, to you.
Ms. Hamsa Kalyani, you're muted.
Hello. Yeah. Thank you very much for the talk and the discussions that Madan also had a number of questions. So the talks were so thought-provoking. I just have one question before, and it's since both of you are in copyright. You're spoken experts in copyright. It's not really to do with open access, because this is to do with the copyright in books, where the publishers actually say all rights reserved in the books. And then it could be with journal articles also. We tend to use a number of images from open access sources in the books. And these are probably sometimes share-alike images and images that can be used. But when you put it in the book, the publisher will say all rights reserved. So is there a conflict? And I'd just like to know from you, what is it that the authors can negotiate with the publisher in such cases?
Arul, I think you should answer this question in entirety. Thank you.
So, what you are mentioning is a very interesting and a frequently happening scenario, because we generally tend to take things from others, but we don't do or we don't engage in sharing in the same spirit. So, as you rightly mentioned, I have also seen many people using images which were licensed under the share-alike license option in another copyrightable work, but with considerable restrictions. So there, what I think we should do is we should somehow persuade the person who created the image to at least sue this guy, because then he is actually violating the provisions of the license, right? So there is a contractual agreement which that particular person is violating when he is including that particular image in a book and not licensing it under the same condition. And ideally people should sue, but unfortunately most of the time people who are sharing also doesn't have enough time to go for these matters.
Yes,
so the
yes.
minimum thing which we should do is send a legal notice to this person, so that at least next time this person will think 10 times before doing this nonsense.
Okay. Thank you very much.
Yeah, now we get started with questions from the audience. I request Dr. Anand Bhairappa to put forth his question.
Okay, thank you, Francis. So it was very, exciting discussions. Thank you for all the panelists and also Madan. So my question is, the topic of the panel discussion is copyright hindrance to the open access. In my opinion, copyright is never a hindrance or a problem to anybody or anything. It is a right and privilege given to individual, and you exercise for your advantage. Now coming to the open access and journal articles context, so that is a privilege, right, you have as an author, as an individual, but you give away knowingly that right because you want global visibility, you want branding, you want to get into elitist class. And also the author community in India and in anywhere, they're least bothered about monetization of their IP, unlike in patents and all. So that is the crux of the issue. And in my opinion, authors and scientists, they're doing it intentionally, and their objective is to get into that elitist class, to get that global visibility, to get that international recognition, and they're not bothered about monetization. Now, on top of it, they come back and ask, I need institution to support. They come back and say, law should support. They don't listen to anything. That is the crux of the issue, if you understand. If open, access, the people, the advocates, if you don't learn to address that, it will never be addressed. And the issue is not copyright, and the issue is not monetization. The issue is author himself. He knows he is the creator. Copyright is his privilege. He is using it his privilege knowingly, but he is not participating actively in terms of getting open access. Now, all these awareness sessions of open access from people like Madan and all with good intentions they're doing, they're only helping publishers to come out with the additional revenue models. I'll give you a practical example. IISc publishes 3,000 papers, and 25% of those articles are getting published in open access. and on average we pay $3,000 per article to publish by APC. That comes to 17 to 18 crores. That is almost 80% to the budget of the library. And that budget, that money we are spending is invisible in the organization. This is true with IITs as well. And because that money is not coming from the institution, mostly it comes from the DST, DBT projects, and that project money is directly goes to author, and he has the APC charges to pay from the projects, and he's paid. So the crux of the issue is author. It's not that they're not aware. They know that because we can't really change them. Most importantly, this is happening only in academics. When you give away copyright, why don't you negotiate the required rights? Okay, I give you copyright, give me permission to use it in institutional repository, give me permission to host inside, give me permission to use the way I want to use it in the institution. They give you. Every corporate is doing across the world. In institutions, in academic institutions in India, they need freedom, they need empowerment. Nobody wants to really go beyond that. That is the crux. The issue is not the law, the issue is not the copyright, the issue is nothing else. That's my understanding. I would like to hear comments of both the panelists on this.
Anubha, would you like to go first or should I comment first?
I'll give it a shot and then I'm also eager to hear you, Arul. Okay, so that's in a very interesting portrayal of the typical author. And I think that definitely enriches this discussion. The other kind of author that Arul's studies point to is the kind of author who has low awareness about open access, the policies. But if, in your view, there is this, and I mean, it's just what I understood from your little comment, that there is a flagrant sort of insistence on not respecting the values or even trying to make an attempt to change in whatever way that they can sort of contribute to change, then our our open access mandates, policies need to have more teeth. Like Arul rightly pointed out, why doesn't the DST-DBT policy have a penalty in case of non-compliance? Who is tasked with enforcing the policy? I think all of these are questions that we need to ponder upon very deeply if we're already witnessing policy failure. So yeah, that would be my sense of how to fix this for now.
Thanks, Anubha. So, Anand, I completely agree with the observations which you made. I think the vast majority of the problems can be attributable to we as individual researchers, because we have certain things to achieve in our life, so we will fine-tune everything according to our requirements. So I think that's one very, very important challenge which we have to face when it comes to framing open access policies. But having said that, I just wanted to clarify one minor aspect here. So when both Madan and I were working as part of the thematic group on access to knowledge and resources, we had to face the same question. Should we be supporting the gold open access journals which are charging article processing charges? And we took a principled position there, saying that for multiple reasons, including the fact that it is unethical to pay for publish, we should not, we as a country, should not support the APC-based gold open access journals. Of course, we do not know what the final outcome would be. But Madan and I had also written a dissenting note very specifically as part of our thematic group discussions. And if you wish, we can also share that particular document, which very specifically mentions why we think that we should not, we as a country should not be supporting this APC-based model. Your concern is absolutely valid. At the moment, many researchers are using public funds from our funding agencies for publishing in their journal of choice, and just because, I mean, that particular journal is open access, and just because that journal, according to their perception, has high reputation. So that's an issue which we as a country would have to deal with.
So can I make an additional comment if I'm allowed?
Yeah, please go ahead.
So we also talk about green open access and institutional repositories in order. You know, in this country, no institutional repository is copyright compliant, because, say for example, we have no mechanism to control or receive it, you know, the right version of the paper at the time of giving from the institute. Nobody talks about that. We don't want to put policies. We don't want to really, you know, instruct authors to give away copy. We don't make policies and all. But after giving away your copyright rights and all, you come back and question librarians and others. What is your IR? Did you get the author version? At the time of giving, you should know why you are not taking that copy. You know, institutions should think about that. Even authors should support that. They don't support that. Once you give away your right, you come back and ask everybody, oh, why are you not making your green OA successful? Why are you not taking your copy into that? You know, that's not the way to work. That's a very, very inefficient way of driving IR. I mean, driving even OA. That's not the right, because you have an easiest way to really get a copy without asking anybody from the author, make it as a policy. And then if you don't do that, I don't think any institution is doing it as far as my knowledge goes. I came from corporates. We had negotiated copyright title transfer agreements with 65 publishers, all commercial publishers. When you give away copyright, you know, you write a clause. If you don't really give me the required copyright for my institution, I resist to publish. But that courage is not there in the academic institutions. If you ask, they give. Do you have a resistance to, you know, say, I don't publish if you don't give? You don't have that courage. You don't do that. We talk about big things, but we don't do practical things. So that's my second opinion.
And again, maybe just quick response there. As I mentioned earlier during the presentation, one of the major issues in this particular regard is lack of awareness among researchers on what rights they have as authors. And I think that's the place where Anubha's suggestion of using an author's addendum makes a lot of sense. So maybe we need to do two things. One, yes, we should use tools like an author's addendum. The second thing is, we also need to create awareness among researchers on what all rights they have as researchers. And if you are doing that, I am sure that we will be able to address many of the issues which you are saying, which includes, say, for example, potentially copyright violating submissions in the institutional repository. But there also, I would say, if someone has a problem, let them come and sue the concerned author, and they will learn the lessons in that manner. But we need not worry too much about that. My bigger worry would be incentivizing researchers for submission to institutional repository. At the moment, we don't receive enough submissions in our institutional repositories, and we need to increase the submissions to the institutional repositories.
Thank you.
Sridhar, can you please come up with your question?
I have a specific question to Arul itself. Arul, the America gives like any author, any scientist employed by the American government, USA government doesn't own the copyrights. If that same thing can be incorporated into Indian copyright law, how it can be? Because I am also a government employee funded by the public funds. I don't take any decision approval from my director or my director general in giving the transferring the copyrights. So when I speak to my colleagues, they say, because you have submitted the manuscript through the proper channel, so they have the approval, and because you own the copyrights, you can transfer it. And when the publisher sends me a mail that you either transfer the copyright or pay €1,000 or $1,000. So in that thing, I want to retain copyrights, and I want to have the addendum and then negotiate with the publisher. But if we had a law, I think half of the councils which are funded by the government or under the government can have this will be default, like they will not be having any copyright, so they cannot transfer the copyrights. So can this be possible? Then how?
Sridhar, very valid point. So, what you are essentially talking about is the so-called government work. So, if a particular work is classified as a government work in the United States, the immediate consequence is that it is considered as in public domain. So, everyone is free to use that and share that particular work as in whatsoever manner they want. But if you look at the Indian copyright law, we also talk about government work, but the difference is that the government will be owning the copyright in that particular work for the same terms which are prescribed in the statute. But one of the areas which I think we need to be a bit careful about is whether the work which you as a researcher doing at a particular government funded institution would be considered as a government work. So if you look at the definition of government work, so it's provided in section 21K, and I'll just read it out, it's just 2 lines. So government work means a work which is made or published by or under the direction or control of the government or any department of the government, any legislature in India, any court, tribunal or other judicial authority in India. So the problem with this particular definition is that it's not very clear cut whether a researcher like you, when you are preparing a particular manuscript during your term of employment, whether that would automatically become a government work. So that's not a clear cut thing. For example, I see that you write so much on open access, but I do also make a presumption that you are doing it most of the time during your non-office hours. So in those cases, my answer would be they would definitely not be considered as a government work. On the other hand, some of the things which you are producing as part of your duty, it's not very clear cut, and we still, at least I'm not aware of any case laws that has really clarified a factual situation like that. Having said all these things, I generally agree with your observation that with regard to the broader category of government work, it is a desirable thing to either put it directly under public domain, or we can take a middle path, that is the path which is taken under the UK copyright law. So in UK, these works will be under copyright and copyright will be existing, but then they will be licensed under the open government license. So at least one of these 2 paths should be taken, and there is absolutely no justification for government to own copyright in these works. I don't see a philosophical or legal justification for doing this.
Yeah. Dr. Shagun, please.
Yeah, thank you, Dr. Francis. Thank you, everyone. I think it was a very interesting presentation and question and answer session, I would say. I have a quick question, although I was part of all the previous discussions as well, both in STIP as well as in our previous OA discussions in the last few years, particularly to Arul and also Madhan here. Do you see any kind of a contradiction where in one nation, one subscription kind of a access policy versus the green open access policy? So I mean, just now you mentioned about the dissent node within the thematic group, which like why you and Madhan and others were particularly against the APC model of paying money to make it open access. Let's say in the German model of gold open access. So we were trying to go away from there and make it in a true sense a green open access. So the plain question here, just for understanding, is do you see a contradiction if one nation, one subscription policy to get access to, let's say, a larger scholarly knowledge available outside versus the publishing model that we are proposing, let's say the green open access? Is there any contradicting viewpoints there?
So Shagun, or Madhan, do you want to go first?
Go ahead, I'll join. Go ahead.
So Shagun, I generally don't see a contradiction between the one nation, one subscription policy and the green open access which we are proposing, because they are dealing with 2 different sets of things. So if we are going for the one nation, one subscription policy, we are able to access materials from across the world. And the green open access policy, which we are talking about, is limited to the knowledge which is generated from within the country, right? So we are talking about two different subject matters. Having said that, yes, I mean, one nation, one subscription as an idea is great, but on the practical implementation, we still have to see, because I mean, my own limited experiences with publishers suggest that they may not come to the table with a reasonable rate. And that's one of the practical issues which I am foreseeing. So unless and until we are having the one nation, one subscription at a reasonable rate, we may not support it. But as an idea, it's wonderful. If all the citizens can access every journal which is published across the world, I think it's wonderful to have. But again, we need to look at the practical aspect.
Correct. To add that, there are two. First of all, the open access is to create visibility for Indian research. Okay, you have to maximize the usage outside India, elsewhere, everywhere. If all the countries follow this one nation, one subscription policy, then the visibility problem will not come. Otherwise, you have to go for the green open access model, because you have to increase the visibility of our research. That is one key problem which Indian scientists grapple with for many years. And green open access is within our reach. We are asking our scientists to share the research findings of the research funded by Government of India. We are talking our scientists to make their papers open, visible. This is within us. When it comes to one nation, one subscription, is about access problem. There are two parties involved. You want to have one nation and one subscription, but the publisher should also agree. There are two-party discussions here. This you are inside love. This is not complete. This transaction is not complete. One nation, one subscription is not going to end with dealing with 4 major publishers. There are about 25,000 scholarly periodicals are being published across the world, and they are publishing something around 2.5 million articles. This one nation, one subscription is a fancy word. It's not going to happen. I would like to, if it happens, I'm changing my view. But at present, my clear view is that publishers are not going to support this decision, because you are trying to gut the duck which is laying golden eggs for them. If I am a publisher, I will not do that. So that's the problem with these two approaches here. This is what my answer, Shagun. Yeah. Thank you.
Yeah, thank you, Madhan. Dr. Francis, if I may just supplement with one more.
Yes, Shagun, please. Fine.
Yeah, thank you so much. Thanks, Arul, and thanks, Madhan.
Quickly here, if I could just jump in. Madhan, I'm actually quite, well, not sad, but I've been skeptical of this idea as well, and I've just sort of published a piece on the Wire. I'll share a link here. But if in your opinion, this is most likely not going to go through, maybe we can have a chat offline. It would be really interesting to understand, because this sort of subscription can provide, it's very, very subjective. It will depend on the negotiation with the publishers. And also, it's not going to come at a very cheap cost. So I share Madhan's and Arul's skepticism here.
Sure.
Yeah. Thank you, Anubha. Thanks, Madhan. I think that's currently still the draft is evolving, and there is a lot of debate internally and externally about. I mean, even it is in media, people are writing within Indian media and outside Indian media to see how it is evolving, right? So one of the observations that I would also like to get from maybe all 3 of you or all 5 of you, including Hamsa here, is, do we see in a long term some kind of a convergence between, let's say, like you rightly said, Madhan, I think you have already charted a roadmap. Why one nation, one subscription, given the diversity of the actors in the publishing world with the mammoth of profit that they are making, is going to be difficult. Let's say that is today. and let's say some countries are putting effort to go towards the alternate path of green open access, and that is progressing slightly in some way, and some wealthy countries are going to take the first path and travel somewhere. So if both the paths can travel for, let's say, 5, 10, 20, 30, any years, are there any convergence? If we know that convergence point, can we work towards backwards? Is there any thought on that?
Okay, I'll take up this. Instead of convergence, what is priority? So if you want to if you want to make publishers come to your line, the green open access should be the priority, first of all. So all Indian research should come to the public domain, and slowly worldwide this will happen. And then the role of publishers will change there. The charges for the entire journal production, the things may change in the future. And the idea of journals, journal production, the way the journals are running now may change. But the 100% green open access should happen. Then only you will be able to expect some kind of a role that publishers can play in scholarly production. Otherwise, whatever you try, this is going to be heads high and tails you lose when you negotiate with publishers. That is what is going to so I don't see any convergence. First of all, I don't believe in this one nation, one subscription is going to happen. Even if it this is going to add profits of publishers in some sense. More. If it happens, they will charge more. So I don't see any convergence can happen on these two routes. But what you should do is, the priority is this green open access should overtake here. Yeah.
Thanks, Madhan. Thanks so much.
Thanks, Dr. Shagun and the rest of the panel. Hamsa, it's your turn.
Yeah. Is it Momita?
Yeah, thank you, Hamsa, and of course, thank you, Arul, Madhan, Anubha, and also Venkat for this wonderful session. So my question is to Arul. So as we from your discussion, we realized that Indian copyright law has it's not very clear on many terms. And now if we go back to the DST-CPR open access policy, we clearly see that that policy mandate is to the author should deposit the postprint within 2 weeks of their acceptance. Now, considering this, there are certain relaxation also that you can have it up to 6 months. But let's say a publisher like Elsevier, where many Indian researcher publishers have this embargo of 2 years. So if now author wants to put it on institute repository, they might have a fear that the publisher may sue them. So in this particular complicated scenario, won't it be good that if DST-DBT do some sort of negotiation with the publishers, or we have some other way around it? So Arul, over to you.
Yeah, so I think Momita, thanks for asking that important practical question. So yes, I mean, this is a concern which is expressed by many researchers. That is, I mean, if you are having an embargo period which is like too less, they might lose out on the opportunities for publishing with a journal of their choice. But I think it is at this point we need to remember that it is the duty of the funding agencies as well as institutions of eminence to push back against journals. So, for example, if IISc Bangalore is taking a clear position that okay, we are not going to allow any embargo with respect to the deposit of postprint, I am sure that Nature will have to change their policies with respect to articles coming from this institution, because if Nature is not getting articles from IISc, they are also at the losing end. And if all the institutions of eminence work collectively in this regard, there is no other way but for the journals to change their practice. So that, I think, should be our long-term goal. Secondly, again, as a short-term tool, we should still try to do with the addendums which Anubha was trying to suggest. And with a combination of both these long-term as well as short-term strategies, we will be able to address the issues which we are discussing now. So, in a nutshell, the right kind of approach is not to increase the embargo period, but to fight out as researchers, as institutions, as funding agencies.
And to add that, this fight is not going to be very difficult. For example, there was a long practice called Ingle finger rule. See, the moment you send a paper to a particular journal, you should not send the same draft to another journal. So if something is published elsewhere, and the journals will not accept your paper. So that became nullified by the growth of preprint repositories. For example, physicists share their preprints in open repositories, and physics journals accept the sharing of preprints, and most of the journals now accept. So as Arul says, if it is a decision by the scientific community, I don't think these kind of implementations, suing scientists is not going to happen. Publishers will not have that much courage, because the scientists are providing raw materials free and the service free. They know the value of scientific community here. So this is not a very serious problem. I think we have to create a consensus among our scientific community. That is actually the problem. The indifference of scientists is a problem here.
So just to continue with my question, may I? So can the library play a big role over here? Because we are seeing that scientists are, because of their career progression and many things, they are not at all into this. But library being really the important tool here. We have even the IISc main librarian people here. So can, as a library, start this as in the IISc library? And also another, that tomorrow we have the two eminent persons from Latin America who are really the pioneers in open access. So maybe having something together, something can be worked out. So yeah, please, over.
Of course, libraries can work as a office of scholarly communication and then help liaising all these issues. Libraries should play an important role in making open access a reality. Yeah, that's my short answer. The other librarians can answer here. Thank you.
Yeah, I also agree that I think the librarians should be doing this much more, seriously. We, we need to promote this open access movement in our own institutions by talking about it more often, and then also putting it into our institute mandates. I think we need to do that, and yeah.
Yeah. Thank you, panelists, for your responses. Now I request Professor Arunachalam to pose his question, please. Professor Arun? Sorry, Professor Abhinandan.
Yeah, this question is about the legal status of the embargo itself. So what status does it have? Can the publisher simply demand that something should not be placed in the public domain or in a repository for, if they can do it for 2 years, they can do it for 5 years, 10 years. What prevents them from doing that? So what is the legal status of this embargo? Does it have any validity at all?
So it's simply based on contract laws, since when you are entering into a publication, you are entering into a contract with the publisher, right? So it has only that as a basis in law. Of course, there are questions as to whether a contract can be against the basic provisions of the law of the land. So if there is a very specific law which says, okay, no embargoes are permitted, then yes, maybe that particular provision can override the contractual provision. But at the moment, at least I'm not aware of any country which is having a specific provision against embargo. So yeah, so they're just riding on that on the basis of contractual.
So I was just reading the NIH policy. It says it should be placed in a public repository in no later than 12 months, right? I mean, it's a requirement. And so if such a mandate is provided by our funding agencies, then I mean we are bound by that, right? I mean
absolutely. Right. So that's the reason why
that is a worthwhile thing for us to fight for, right?
Exactly. So that's the reason why funding agencies as well as the institutions should try to have these kinds of mandates, so that, I mean, when the researcher goes to, say, for example, Nature for a publication, they can show that, okay, there is a mandate like this from my funding agency, and if I'm going to violate it, I will be punished. So if that is the case, I am sure that these people will definitely agree to the terms which we are suggesting. So we can always show the mandate and then negotiate.
Exactly. At some level, they've already agreed to all that in the case of NIH and other such agencies.
Absolutely. Yeah. So it's time for the Indian institutions as well as Indian funding agencies also to push back against the public.
Okay.
And publishers are helping scientists to comply with the NIH mandate. They are openly helping there. Yeah.
Right.
Dr.
Thank you very much. Madhan, how long do we go on?
One last question. Probably Professor Arunachalam is raising his hand, and with that we can stop.
Yeah. Yes.
Okay. Sure.
Dr. Arunachalam, please.
His mic has some problem. I don't know. He can come to video.
Video?
No. You can try your question, sir.
Are you hearing me?
Yeah, yes. We are hearing you.
Okay.
Little closer to the mic, Professor. Yeah.
Fine. Go ahead, sir.
Okay. Regarding this, negotiation with publishers, I may like to marry the emperor's daughter, but the emperor or the daughter like to marry me? That's the question. You may ask, we will like to get all the journals at a single price for the whole nation. There's no need for the publisher to agree, because the publisher gets a huge sum of money at the moment from subscriptions to different institutions. The publisher doesn't have to lose so much sum. A couple of years ago, maybe 2017, there was a correspondence between Ricky Poinder and Peter Suber. Peter Suber, the doyen of open access, made this point, stating that this probably may not happen. Eventually, you may have to settle for something which is more realistic. That's the point he made. Also, the publishers, way back in 2007, July, I think, the Elsevier, Wiley, American Chemical Society and all, went and hired a very tough and rough PR consultant, was referred to as a pit bull in the PR circles, to advise them how to overcome this problem of scientists hankering for OA. He said simply, you have to tell that OA is nonsense. Peer review is equivalent to subscribed journals. That's the way it is. And I have sent it on the meeting chat page. You can look at it later. So there are issues. The publishers do not want to let their profits go. If you want to know, Elsevier makes, for the publishing section alone, 35 to profit annually, year after year, in several years in the past. Okay? So they would like it to go. And I mean, the same may be the case for several others. As recently as a few days ago, Nature entered into an agreement with the German institutions for agreeing to publish papers from those institutions for a publishing fee of approximately $10,000, upwards of 9,000, close to 10,000. Now, how can anybody agree to such an agreement? In their wisdom, the German universities have agreed. I do not know how long will it go. Soon enough, they will realize it's an impossible contract and they may withdraw. So one has to be extra careful in talking about such things, about one nation, one subscription and all. They are not realistic at all. Okay.
This is an answer for your question, essentially. Yeah, that's all. Yeah.
I ask one question?
I don't know the panelists. It's already 2 hours. Shall we? Yeah. Who is that?
Yeah.
Yeah. Please go ahead. Please go ahead.
Okay. I'll make my question short one.
Please.
There are 3 versions of a paper these days. The first version is a preprint version, which author is supposed to deposit in the repository. The second is the one that the post-print, what you call, or is normally known as author-accepted manuscript. That is post-peer review. The third is the published version. Now, the preprint version comes out first. So the author has fixed by the process of writing and depositing in a repository. Having fixed that, he has automatically got the copyright for that version. Now, when he, second level, he transfers the right to the publisher. When he transfers the right to the publisher, what happens to the copyright of the preprint version? Number one. Number two, the author-accepted manuscript. That is basically a version of preprint. The only difference is it is peer-reviewed. The value addition is a peer review process. So peer review is, but that will not, by process of peer review, copyright cannot go to the peer reviewers. They are anyway anonymous. Now, who will own the copyright for this middle version, that is author-accepted manuscript, the post-print version? Print version, of course, the publisher certainly has the copyright. So my question is, will the copyright for preprint version continue even after the publisher has taken the exclusive right, because author is giving away exclusive right? And second, what is the copyright status of the intermediary version, that the author accepted manuscript?
Thank you very much. It's for Arul and Anubha. Thank you, Satya. I think your name was not visible for us. Yeah.
Hello.
Anubha, do you want to answer? Anubha?
Sorry,
Okay.
I didn't catch some parts. If
Okay.
it's possible,
No
Arul, you could go ahead. Sorry.
Yeah. So Satya, I think thanks for raising that important practical question. So as you rightly mentioned, yes, I mean the first copyright will be coming up the moment the person writes that initial manuscript, and then of course during the peer review, yes, based on the comments, they might have to make certain changes, and then there will be a new version coming up. So there are 2 independent copyrights existing here. So the one is the first one, the initial draft. The second thing is a modified one, which is actually creating a new copyright, which is starting at a different time point. So it can be like after 1 year or whatever it might be. In general, the publishers demand transfer of copyright ownership after the peer review. So after you have incorporated all the suggestions. So once what you call as the author accepted manuscript is submitted to the publisher, yes, then they ask for the copyright transfer. So generally, on the preprint as well as the middle one, which you call as the author accepted manuscript, it is a author who is retaining the copyright. But then, yes, as you rightly pointed out, in the final version which is being printed, there are also more things coming into picture, which includes the typesetting, everything, right? They are putting it in a specific layout and so on. So there again, a new layer of copyright is coming, and there, because of the combination of both the other additional inputs which they are putting in, yes, the publisher might be owning the copyright. I just want to add one minor clarification here. Not in all cases the publishers would demand a copyright transfer over the author's accepted manuscript. So in some cases, the authors will continue to retain copyright over their publication, and the publisher would be having copyright only for that minor addition which they made in the final print version, which is like putting the layout designs and so on. So we'll have to segregate it during a litigation. So different copyrights will be existing in this particular subject. Hope it clarifies.
Yeah, but then who is the owner of the intermediary version, the author accepted?
Generally, it's the author. Author will be the owner, and then after that, yes, there is a copyright transfer that will be happening. Yes.
But many of the publishers are putting a condition that author accepted manuscript cannot be immediately put in the repository. Some publishers are putting a time limit, an embargo limit, and some publishers say that it can be put only after the article is published.
Yes, sir. So again, I mean, they are doing it not based on copyright law, but based on contract law. So when you are engaging in a publishing contract with Nature, yes, it is for them to put whatever condition they want, and then it is for you as an author to negotiate and see whether they will change the position. So generally, I mean, yes, they go with a standard template contract wherein you can see provisions like this. But yes, if you are a very prominent author, I am sure that these guys will change the provisions for you. And if you're coming from a prominent institution, yes, there is a great leeway which you will be having. And as researchers, we all should collectively try to ensure that these publishers are not going with standard template contracts, but they are going with waivers.
Since the author is giving away exclusive right to the publishers in almost all the cases, through a contract, will that contract law influence authors' continued retainership, continued retention of the copyright on the preprint version?
So it won't. So the copyright over the preprint will be still existing. So we'll have to see them in an incremental manner, right? So the copyright over the preprint is existing, and then there is a copyright over the final accepted manuscript, right? So these are two different ones. So there are value additions that happen, and generally it's only for there is a new copyright existing for those new value additions that had happened. I just wanted to also make one additional point here. I see completely that there is an imbalance in bargaining power here. So basically the authors are generally at a weaker position when it comes to bargaining with publishers. In the history of copyright law in India, we had seen a similar conflict elsewhere, that was between musicians and the recording companies. And thanks to people like Javed Akhtar, at one point the parliament intervened, and then they made certain changes in law which said that, okay, there cannot be, say for example, a grant of rights to future media. So for example, if there was a media which was not in existence today at the time of my contract, and if the contract is saying I am granting it my rights over all existing and future media, that's now illegal. So there is no legal sanctity for such a contract. But that happened because of the extensive law being done by musicians and composers under the leadership of Javed Akhtar. A similar move can happen from the side of researchers also. Maybe we should wait for that day. Thanks.
Okay, thank you very much, and thanks to the organizers for a very engaging program.
Thanks, Satya, for a wonderful question. I think this is an important question. I think we may stop it here with this wonderful note and question from Satya. Frank and Hamsa.
Actually,
yeah.
Hello.
Yeah.
May I put one question with it? Last question you can consider.
Please go ahead.
Yeah, actually, thing is now Dr. Arul has said that in an NDL document, chapter, not only chapter, whole book can be given copy for educational purpose. That is the judgment
during
of
the
Delhi.
course of instruction. During the course of instruction. So there are different educational uses exceptions under copyright law. So the one which I am talking about is section 52(1)(I), which is talking about uses that happen in the course of instruction.
Okay. Now my question is, nowadays because of COVID, teachings are on online, and naturally faculty and students are asking for e-books. Now you know that publishers' policies are DRM, cost, prices, this and that. So now my question is, when can librarian change the format of the book or chapter and can give it to the user for academic purpose or research purpose? Can we scan?
That's an excellent question. So I mean, for those who are not familiar with the question which she is asking, so in the year 2012, I mean, we made lots of amendments, and one of the amendment was specifically relating to anti-circumvention measures. So basically what the law is saying, if a copyright owner has put in technological protection measures, say for example a copy lock or whatever it might be, and if you are circumventing that, then you are liable for two things. So one is you will be liable for copyright infringement. Second is you will also be held liable for breaking that particular law which has been put in by the copyright owner. Of course, it's a very, very stupid provision, but we are doing it because we want to be a part of two international treaties. That's the only reason. So, but yes, that's a law now. But now, if you look at our copyright statute, at least thankfully, when they included this particular provision, they also very specifically mentioned that you can circumvent the technological protection measures provided it is for a purpose specifically permitted under copyright law. So now, as I mentioned earlier, our law is very specifically saying that for educational uses, and more specifically in the course of instruction, if a particular faculty wants to share a particular article or a book or book chapter as a reading material, and as long as he or she can justify the inclusion of that in the course materials, then yes, you are allowed to share it. And if an exception like that is provided already under section 52(1)(I), then yes, we can make use of that particular exception, and you don't need to worry about the breaking of the technological protection measure. And the act, thankfully, again, I mean, the international provision is not that, I would say, broad, but at least when India implemented this provision, since we had the opportunity to see what wrong was happening in other jurisdictions, thankfully, we also said that in such circumstances, we can also take the help of people who have expertise in breaking the code. So two things. One, yes, as long as it is for a purpose which is permitted under the law. Second, then we can also take the help of people who are having expertise. So for these two matters, I would say, yes, we have taken a liberal position there. But I again repeat, ideally, we shouldn't have gone for this anti-circumvention provisions under our copyright law. But anyway, that's part of the law. But thankfully, at least we have some exceptions there, and you can certainly use that, provided your faculty members can justify the circulation of that particular reading material as an integral thing for their course.
That means we can scan it because I have gone through Copyright Act 2012. I couldn't get any specifically the clause to transfer the format. But
so basically,
it may be interpretation.
Exactly. So unfortunately, we don't have a specific case law that can guide us with respect to this anti-circumvention provision. Thankfully, no one has sued anyone under that particular provision so far. At least there are no reported judgments from the High Court. But the general interpretation and also the spirit of the provision is that as long as it is for a purpose which is specifically permitted under the law, and as I mentioned earlier, educational use exceptions are existing under section 52, then yes, it is permitted. So you can actually circulate that either by scanning or by using some other breaking measures.
Okay. Thank you very much. May I request the most recent intervention guest? We don't see your name. It just says VK on your handle. May we request your name, ma'am?
Actually, I'm Vishaki, Dr. Vishakhi, librarian, Aizer Mohali.
Aizer Mohali. Okay. Thank you very much.
Yeah, thank you.
Thank you very much.
All right, this has been a wonderful panel discussion. I would like to thank on behalf of the Open Access Week organizing team at the DST Center for Policy Research, all the panelists, Ms. Anubha Sinha, Dr. Arul Scaria, and our moderators, Mr. Madhan Muthu, Dr. Francis Jayakanth, and Ms. Hamsa Kalyani for stimulating discussion on wide-ranging topics. The discussion has been so wide, the title of the panel made little sense towards the end. It's been put to rest in the first 5 minutes. We would also like to thank Professor Arunachalam for his continued support at our center and in organizing the OA week and in educating us on these extremely important matters, without whose support the whole event would have not been possible. I have two final remarks. Tomorrow we have our last seminar as part of the series. We have two speakers speaking on the Latin American experience on open access. And then finally we'll end our second webinar with this. I request everyone who would like to be part of the photograph to please turn on their cameras. And I would like the whole team to help me get a screen grab.